What is proportionality? How many civilian deaths are too many civilian deaths? 15, 600, 40,000? Are there circumstances that call for exceptional force? Applying international law out in the field is very different from deciding in the safety of a courtroom. How can an officer in the field be expected to decide how much damage is proportionate? Is there any guidance that can help in decisions about proportionality under fire?
The answer to that in about 30 seconds. A couple of years ago, I participated in a conference like that in one of the universities, and the room was packed, almost as it is here, a few hundred people, and vibrant discussions. At the end of the conference, I asked my friend who organized it, wow, how did you look at this university? So many students. I said, are you crazy? All the professors forced their students to come to the conference. That's why the room is packed. So I want to express my amaze at Nitsana and this lovely organization. This is by far one of the most impressive conferences so far, and an amazing turnout. We lawyers, jurists, distinguish between two kinds of questions. Those of you who still remember first year of law school, jurisprudence or legal theory. The first questions deal about the technicalities of the law. We call them internal questions of first order. And the second type of questions are questions about the law, meta-legal questions, questions about the interrelations or interactions between the legal doctrine and other fields of morality, culture, etc., etc. It seems to me that the area of the laws of war raises a number of very, very interesting and perhaps very, very difficult questions of the second order, meaning how do you justify laws of war? Because the idea of restraint on the expense of victory doesn't resonate sometimes as being extremely logical, maybe perhaps even immoral. We'll get to that after the initial presentations. Right now, I think we want to focus on the questions of the first order. I want to develop a discussion about understanding the applicability or interpretation of the doctrine of proportionality. Now, those of you who are familiar with the Dworkin's distinction between rules and principles, we were talking about a principle of proportionality which, by definition, requires interpretation, can be expanded, and widened or narrowed, and raises important questions of subjectivity, interpretation, and when do we apply it. I'd like to first introduce our guests, and then I'll lead the discussion, but by order of seating, I'd like to first introduce Professor Robbie Sable. He's a professor of international law at the Hebrew University of Jerusalem. He served as legal advisor to the Israel Ministry of Foreign Affairs. His numerous publications include Procedure in International Conference, and I would say he's a world-renowned expert on international law. Thank you for joining us. To his left, Professor Yuval Shani, I think, who's made the least effort to come, just across the street, right? He's the Dean of the Faculty of Law at Hebrew University. Professor Yuval Shani is a member of the UN Human Rights Committee. He served as a research fellow and a professor at Harvard University, Columbia University, Georgetown, University of Michigan, and the University of Sydney. Thank you for being here. These are the only two legal experts only. Now we come to the soldiers, I guess, right? Professor Jeffrey Korn is a professor at South Texas College of Law. Mr. Korn spent 22 years as a U.S. Army judge, advocate, officer, and civilian attorney. His military career included service as chief prosecutor for the 101st Airborne Division, chief of international law for the U.S. Army, Europe and Regional Defense Council for the Western U.S. Thank you for being with us. Professor Eugene Kantorovich is a professor at Northwestern University School of Law. His areas of specialization include international constitutional law and especially maritime piracy, which seems somehow romantic to me. I never knew that lawyers deal with piracy today. His book, Justice at Sea, Piracy and the Limits of International Criminal Law, is to be published soon by Harvard University Press. Thank you for being here. And last but not least, Professor Chris Jenks is an assistant professor at Southern Methodist University. He's a Fulbright scholar researching how emerging technologies affect accountability in armed conflict. He as well served as in the US Army for more than 20 years in US, Europe, Kuwait, and Bosnia. And he wrote the rules of engagement crucial to the success of the first free elections in Iraq in more than 3 decades. Just for that, he needs an applaud. Thank you very much. I would like to first ask Professor Shani to actually briefly present and discuss some of the aspects of the proportionality doctrine, and especially what does human rights approach to that principle entail. And I just got to warn you, have 10 minutes, and I'm going to stick to my gun. So.
But proportionally, I hope. Okay, thank you very much for the kind introduction, and this is really a very impressive room. We don't normally force our students to come to conferences.
It wasn't Hebrew.
But maybe we should. So congratulations to the organizers. There is little question that the principle of proportionality is really a key principle in modern IHL. Especially for militaries like Israel or the UK or the US, where one is dealing either with professional soldiers or with well-trained soldiers that do not target civilians intentionally as a matter of policy, and that have sophisticated weaponry that may enable them to distinguish in their operations, usually between civilian and non-civilian objects. So modern militaries, certain militaries of democracies, of liberal democracies, do not deliberately kill civilians as a matter of policy and do not normally resort to indiscriminate use of force. There are, however, questions that do arise, even for such militaries, that do pertain to very difficult decisions that have to be taken on the battlefield, and Colonel Kemp addressed some of these dilemmas. For instance, how much efforts would a military like to invest in providing advance warnings to civilians before an impending attacks? What weapons to deploy in a given situation where you're often facing a choice between acting quickly with a weapon that is immediately available but may entail collateral damage, or waiting a little bit longer, for instance, for reinforcement with other weapons to arrive, but then, of course, you lose precious time. And what sort of risk should one be ready to expose one's own soldiers in the battlefield? And all of these questions, which raise difficult operational questions and moral dilemmas, in IHL boil down to the question of proportionality, namely the need to balance, on the one hand, the dictates of military necessity, and on the other hand, the need to avoid as much as possible collateral damage, namely harm to civilians and to civilian objects. And these are the types of questions which the International Criminal Tribunal for Yugoslavia's prosecutor's office had explicitly referred to as questions on which sometimes reasonable minds may disagree, and that a military commander may approach differently these kind of issues than a human rights advocate. And I believe that the recent round, I was going to say hopefully the last round, but we probably should know better, that the recent round of violence in Gaza raises a lot of these issues. And it's hard for us, actually, not having the privilege that Colonel Kemp had of sitting in the actual places where decisions were made and monitoring the situation from up close, to assess whether the decisions that have been made have been in compliance with the principle of proportionality or not. Those of us who know the IDF and know the way it operates and know to what extent our lawyers, some don't like it, but this is the truth. Lawyers are involved in the decision-making process. Give, of course, the IDF the benefit of the doubt. And those who do not have this kind of trust in the IDF or come from a very different perspective to view the Israeli Palestinian situation often refer to the high numbers of civilian casualties and perhaps the low number of legal proceedings in the aftermath of the conflict as indicative of violations of the principle of proportionality by Israel. Now, I do not want to enter these questions because they basically revolve around facts and they revolve around institutions, and the dust has not fully cleared in the sense that the IDF is still conducting investigations, and I personally have a lot of faith in these investigations, and I'm awaiting to see their outcome. I do want, however, to touch upon, in the limited time I have, I do want to touch upon 2 points, one of which also are raised by Colonel Kemp, which I think are important in terms of moving forward the doctrine, because this conference is trying to investigate whether there needs to be a new law of war. And one issue has to do with the role of human rights law in dealing with proportionality analysis. And the other issue has to do with particular strategic and cultural factors that may affect the calculus. So with regard to human rights law, I don't want to enter into the whole discussion. Let me just go really quickly to the bottom line, and that is that there is very limited controversy today that human rights law apply in times of war as a matter of legal doctrine. This has been accepted by every international legal institution that has examined the issue, and it has also been accepted, as we've heard, by courts in the UK and to some extent in Israel and in the US. So the doctrinal question as to whether human rights have a place at the battlefield has been determined as a matter of law. The devil, however, is in the details, because whereas almost everyone would agree that human rights would apply, and that they would apply to address some issues that are not actually regulated by the laws of war. For instance, the whole military investigation process and the independence of the investigating authorities is not something that IHL has traditionally developed. So when you have a gap in the law, and you have a body of law which is relevant and which is available, it makes a lot of sense to resort to that body of law in order to fill in gaps. And indeed, the Turkel Commission that reviewed IDF investigations into allegations of war crime did pronounce that the basic principles of investigation that derive from human rights law would also apply to investigations conducted in the aftermath of a military operation. So the investigator has to be independent, and the investigator has to be impartial, and the investigation has to be credible and effective, and to the extent possible, transparent. So this is really, I don't think that here we have a lot of disagreement. Maybe I stand to be corrected by my colleagues on the panel. And I don't think we have I don't think we also have a serious problem. Where it gets more difficult is that we are, when we are moving to areas where IHL actually regulates an issue, like the use of force, like proportionality. And here I tend to agree with Colonel Kemp that we are seeing, and this has nothing to do with Israel, it's important for me to state, this is not something which is driven by an Israeli agenda. The main decision on this issue has been delivered by the European Court of Human Rights with, believe it or not, with respect to the military operations of the Russians in Chechnya, where the position was, and I'm going to just read one line from the decision. The court basically said that because Article 2 of the Convention, the right to life, is under unique challenges, is being threatened in the times of war because of the difficulty of the situation, then the circumstances in which deprivation of life may be justified must therefore be strictly construed. Namely, this co-application of human rights and IHL posits that you have to work harder in times of war to protect human rights. You have to place the burden on the military higher than in times of peace. And I believe that the Goldstone Commission, when you clear away a lot of the background noise, I think this is where I and many Israelis disagree with the Goldstone Commission's approach, namely to say that Israel did not conduct effective warnings when Israel, and I think Colonel Kemp has written about this, went into length that no military in modern history has gone to with respect to providing effective warning. I don't think it is driven by an anti-Israeli or mainly driven by an anti-Israeli agenda. I think it is driven by a human rights analysis of what are the obligations of a government on the battlefield, and I think this is putting the laws of war on its head, and this is something which we need to be concerned about. At the other hand, and now I'm going to push it a little bit in the other direction, and I hope
90 seconds gone.
I hope you'll give me 2 more minutes. And this is, now it's injury time, I know, I have to be very, very brief. What we are seeing, on the other hand, are attempts to argue that because of the unique situation that Israel is facing, and because of the specific nature of Hamas, and because of, for instance, Israel's greater sensitivity to the lives of its soldiers that manifests itself in the rate of exchange, so to speak, that Israel is willing to introduce in prisoner swaps, as we have seen in the Gilad Shalit exchange, then Israel should be given greater leeway in applying force when applying the proportionality analysis. And I think this is also a dangerous road to take. It's a road that has been taken recently by 2 very senior U.S. former military legal advisors. I think one maybe Miriam is still current. And I think in the same way that we should be very careful about changing the equilibrium of the principle of proportionalities in ways which is totally victim-oriented and disregards the operational logic of the military, we should also be careful to superimpose on the very specific tactical equation general considerations that the soldier judge in our little film has absolutely no capacity to weigh. So I say, with respect to proportionality, the law strikes a reasonable balance, and we should resist, and I know I sound very conservative in saying that, I think we should resist attempts to upset the balance and to strengthen victim protection at the expense of operational logic, but also to do away with the need to protect innocent civilians in the name of broader strategic or cultural sensitivities. Apologies for stealing 2 minutes from you.
Thank you very much, Yuval. I think, as you rightly said, the devil's in the details, because I think no moral human being would disagree that the principle of taking or causing excessive and unnecessary damage in any circumstance, being wartime or non-wartime, is immoral and therefore should be probably should be banned. But I want to ask you, Professor Kontorovich, what is your problem with the principle of proportionality, if you have one? I think you do. Is it with the principle, or with its application, or with the attempt to sometimes try to capsulate moments of war into legal rubrics, which is a poor shot? Or what is your difficulty with the principle?
Okay, thank you. So we have a few questions. First of all, what is proportionality? And secondly, and this is actually much more important, who decides? But first, let me take a moment to note the extremely disproportionate attendance and turnout at this event. It's really quite extraordinary. I've organized conferences and spoken at many conferences in the United States, which has a population vastly larger than Israel. And for conferences, for members of the general public, one could never imagine even half this attendance. Again, it's not because these issues aren't relevant to the United States. Right now, for example, there are allegations about airstrike in Syria, which killed many civilians. These are issues that could be of interest to the United States. I can't imagine that a conference in France, where there's now an extraordinarily serious scandal about practice of systematic rapes in Central African Republic by French peacekeepers. I can't imagine such a conference attracting this kind of public turnout, and I'm not sure that it's an entirely good thing.
But Nitsana asked me to give you extra 2 minutes for that,
okay. And
she mentioned that people actually paid to get in, so it even makes it more.
That's really goes beyond. So there's clearly a disproportionate interest in, or emphasis on, proportionality. So the first thing to clarify, and this may be basic, but it's so important in the public discussions of the proportionality principle. There is, in fact, a proportionality principle in the use of force in military operations, but it is almost always fundamentally misdescribed in public discussions, in media discussions, which seem to take the relevant proportion as the proportion of dead on both sides, a ratio of the casualties of the combatants. Whatever proportionality is, it has nothing to do with the ratio of casualties of the combatants. One obvious proof of the absurdity of this principle, take, for example, the United States military operations in Libya. So the US casualties, fortunately, thank God, were 0. There were several hundred dead Libyan civilians. That would make it infinitely disproportional. And it was a well-run campaign. So the notion that these ratios matter is obviously disproven, and it's just not what it says, right? Rather, it's the ratio, the relevant ratio is the ratio between the intended, hoped-for military advantage that the operation is designed to secure and the collateral consequences and damage to the civilian population. That's the right ratio. And one sees a problem immediately with this analysis. Prospective military advantage. How do you measure that? How do you measure that? What's the metric? What's the unit? That's one question. Versus potential civilian casualties and harm to the civilians. We know how to measure that, but already we're talking about one thing that we don't know how to measure and another thing that we know how to measure and is measured in different units. Right? So it's apples and oranges. Right? And that's if we knew how to calibrate the scale. Right? International law says it has to be, an attack has to be proportioned, but it doesn't say what the proportion is. Is it 5 units of military advantage to 1 unit of military harm, or of civilian harm, or is it 1 to 5 in the opposite direction? So we don't know exactly what the proportion is. Something reasonable, but that's very hard to formulate. So it's a very general rule. And how are you going to figure out what a general rule is? So there's one way which would seem obvious and is almost never done in international law, which is look, if we're interpreting truly international law, right, law that is law because countries have accepted it and countries are applying it as such, the normal way to understand what it means is to look at what countries do. Right? In the siege of Fallujah, what was the proportion? Right? Let's assign numbers and figure it out. And that way, commanders would know exactly what to do. 1 to 5 or 5 to 1, whatever it is. And that would offer an amazing ability for comparison. Right? And indeed, there are lots of military operations around the world conducted by Western countries. There's what to compare to. But this requires lots of nitty-gritty. Right? This would prevent professors from spouting off in the press right? Is this airstrike proportionate? Right? Is the one in Syria that I just mentioned proportionate? I don't know. I'd have to really sit down and spend a few weeks looking at similar situations and figure out the proportion. So that's one way to do it. But again, it's a very general standard. And in law, when we have general standards, what's a general standard as opposed to a precise rule do? Right? We can't have a precise rule because it's supposed to cover too many unknown situations. So we have a standard. Usually what a standard in law does is it delegates power to subsequent decision makers. That is to say, the more general and less precise the rule, the greater the power held by the person who ultimately decides. And so the question is, who ultimately decides? And it's important to note, who decides has great power. Right? Has really power over military operations based on a general standard. But it's not obvious that the operation of this delegation is the same as a normal delegation in a legal system. Normally in a legal system, when you have a broad rule, who decides what it means? First the people who apply it, and then the courts. Right? And then the courts. But in international law, barring membership in relevant treaty-based courts, there is no ultimate decider. Right? There is no ultimate decider. And the principle of proportionality is designed first and foremost for the commander, for the person making these decisions, which is why the principle is phrased so strongly in the information available to the commander, in the perspective of the commander, in the situation of the commander. So, guidance for the commander. Ultimately, the broader and more general the rule, the greater the power of the ultimate decider. So we have to really think who are the ultimate deciders. And that's why there are so many people who want to be the ultimate deciders. The ICRC, law professors, everyone wants to be the ultimate decider because a lot comes with it. But given that international law, in its simplest sense, does not have ultimate deciders for relatively closed questions without particular agreement of countries, it would be surprising if it has created a particular decider in general here. Okay, so data is very important. Data is very important. Now, Dean Shani mentioned the notion of particular versus general approaches, and I entirely agree with him that it would be completely inappropriate to have a generally different standard for Israel, that is to say, a generally more permissive standard for Israel than for any other country. But again, the question is the level of generality. Right? The question, so clearly Israel shouldn't have a different ratio. Right? If the ratio is 1 to 5 or 5 to 1, that's the ratio for Israel. However, facts do determine what is a concrete military advantage. Take, for example, the so-called Hannibal Doctrine of the Israeli army, supposedly against allowing prisoners to be taken. There's a reason the doctrine exists, and the reason is Hamas works very hard, Hezbollah works very hard to take prisoners. They do so for a reason. They do so because they perceive a military advantage in it. It's not that Israel is willing to trade lots of people. They demand to trade lots of people. And it's a fact about the world that this happens. And it's not just a fact about Israel. It's a fact about both sides. That is to say, the other side structures its operations and goes to great lengths that most other forces wouldn't to take prisoners because they know this can give them an extraordinarily strong advantage. That is a tactic. It is a tool. It is a military tool. Negating a military tool is also a military tool, and it would seem to me would have to at least be factored into the principle of military advantage. So you can't look at Israel in general separately, but particular operations have particular characteristics. Clearly, for example, Israel can't ignore the fact that the use of human shields increases the civilian cost. That needs to be taken into account in the proportionality calculus. That's the other side. But similarly, to not take into account that a concrete military advantage, a method of attaining military advantage, is the taking of hostages and the keeping, I say hostages because they're not treated as prisoners of war and they're held for ransom and information is not provided accurately about them to their families. That is a tool of warfare, of psychological warfare, explicitly. That is to say, it's not that Israel has decided to call this a tool of warfare of the other side. It quite clearly is. They play all sorts of games with the families. Are they alive? Are they not alive? Are we going to give them to? Are we going to give them pieces in pieces? That's a tactic. Negating a tactic is also, that doesn't answer the question. Right? That doesn't answer the question. Is the Hannibal Doctrine proportionate? Right? But it is clearly addressed at securing a real military advantage. And again, the fundamental question at the end of the day is, who does the international legal system, the Geneva Conventions, which drafted these principles and put them in the vaguest terms, who has it given this power to? And in international law, if you lack and here again, Dean Shani and I disagree, if there's a lack of a clear answer, it doesn't necessarily mean you need to make up an answer. International law is not like regular law. It is underdetermined. It is thin. Usually there aren't answers. Right? And the status quo answer is countries decide for themselves. Again, they should take that inquiry very seriously. The IDF Military Advocate General should take that inquiry very seriously. But we need to understand that the creating of a broad rule creates extraordinarily broad power for its ultimate interpreter.
Thank you, Eugene. Both of your presentations have left out, obviously, you're not asked to talk about these, whether the application of the rule varies when you shift it from the international law, meaning between a state of war between two states, as opposed to asymmetric warfare that current liberal democracies are facing currently in the past years. So I'd like to ask you, Professor Jenks, how do you see this shifting? Does it cause any reason for more difficulties? Is the application smooth? Do you see that as a potential for more interpretation, more subjectivity?
Thank you, and thank you to Shurat HaDin for the privilege of visiting Israel for the first time and the opportunity to participate in this important event. And I sadly share my colleague's comment about what attendance would be like if this event was being held back at the United States. Although our technique in the U.S. is we will offer food. So I've found that law students, at least, will go to pretty much anything if you can bait them with pizza. The absence of food means they will attend to nothing. My remarks today ask whether some of the difficulties in applying the proportionality rule stem from the rule's origin in international armed conflict and the attendant tolerance in international armed conflict for levels of death and destruction. The proportionality rule is the most misunderstood and misapplied aspect of the law of armed conflict. But that doesn't mean that we need a new law of war. The problem isn't with the law as such, but rather with its underlying difficult policy choices. When a military commander knowingly takes action which will likely have deadly incidental effects on civilians. I think we should recognize the proportionality rule's inherent difficulties and minimize being drawn into unending and frankly unwinnable debates which inevitably follow whenever the rule is invoked. The proportionality rule limits incidental destruction and damage of persons and property. And we see early versions of the rule as far back as the Lieber Code of 1863 in the United States, various Hague rules at the turn of the 20th century. But the modern conception, the formulation at issue for our purposes here today, is found in Additional Protocol 1 to the 1949 Geneva Conventions. And under Article 51 of Additional Protocol 1, indiscriminate attacks are those which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. Almost every word of that definition is and has been subjected to debate. While not taking anything away from those discussions, I suggest the micro nature of such analysis possibly overlooks a macro point concerning societal acceptance of damage and destruction in armed conflict. On the whole and on average, I think we tolerate more damage and destruction during international armed conflict than in non-international armed conflict. In that sense, I don't think we should be surprised that we struggle with the application of a permissive international rule in a more restrictive, non-international armed conflict environment. Obviously, application of Additional Protocol 1 is predicated on international armed conflict. And we know that there is an unfortunate, perverse imbalance between the type of armed conflict and the applicable law. Roughly 90% of the law of armed conflict applies to international armed conflict. Yet international armed conflict accounts for less than 15% of the armed conflicts which have occurred in the last 50 years. Instead, the vast majority of the armed conflicts are non-international in nature, but for which there is a paucity of law. To a large degree, the divide between the law applicable to international and non-international armed conflict has been bridged by policy, practice, and decisions from international criminal tribunals. The underlying rationale behind applying the more robust body of international law, or international armed conflict, to non-international armed conflict, is to advance the protective function of the law. The law's function at its essence is to protect civilians and those or to combat. So those never involved in hostilities and those who by virtue of having surrendered or been wounded or sick are no longer involved. And I think that's the case for virtually all the law, that applying it in a non-international armed conflict in the same way as we do in an international armed conflict advances that protective function. But on proportionality, I'm not so sure. I think our tolerance for incidental death and destruction is at its height in international armed conflict. There are, of course, have been horrific civil wars and other armed non-international conflicts. And there are some international armed conflicts, of limited duration and intensity. But on the whole and on average, when we think of World War I, World War II, we recognize that the amount of incidental death and destruction associated with international armed conflict is greater. So we have a rule which codifies this tolerance, the proportionality rule of Article 51. It provides a ceiling that incidental damage and destruction cannot be excessive to the anticipated military advantage. But is that ceiling the same? Do we have the same tolerance? I'm not so sure. I think the answer, frankly, is not only no, but clearly no. We elsewhere limit ourselves in non-international armed conflict in ways we don't in international. Consider the Israeli Supreme Court's targeted killing case about different and higher standards. And yet we apply the same proportionality ceiling from international armed conflict. And while the debate over proportionality tends to focus on arguing about the meaning of expected, excessive, concrete, or military advantage, I wonder if to some extent those are manifestations of the dissonance from this macro point, that the proportionality rule origins in international armed conflict prevent implementation, or effectively anyway, in international armed conflict, unlike many other aspects of the law. In my view, the proportionality rule's primary utility is that it codifies the reality that some incidental death and destruction is tragically implicit in warfare. But treating the acceptable ceiling as qualitatively the same in non-international armed conflict as international is to enter a almost intellectual tunnel which lacks a coherent path or an endpoint. For proponents of an operational approach to the law of armed conflict, and I certainly consider myself one of them, our time and efforts would be better spent, in a relative sense anyway, in not taking the proportionality bait from lawfare proponents. Thank you.
Thank you very much. I think another very important aspect of asymmetric war is the issue of reciprocity, or actually lack of reciprocity, meaning usually there's one state which tries to abide to laws of war, and it's facing an organization or a terror organization that has no respect for any legal doctrine. Now, the question is whether that has any aspect, or that has any influence on the behavior, or should have any influence on the behavior of the law-abiding country. That's a moral question, but I'm more focused, I'd like to hear Professor Sable. Does that have any legal significance, meaning whether one side abides to or attempts to abide and the other doesn't? Whether reciprocity could be trickled into legal doctrine, and if so, to what extent?
Harel, thank you for the cue. First of all, if I'd like to express a personal appreciation for the work done by Shurat HaDin. The policy policy reminds me of the old slogan of the Salvation Army, why should the devil have the best tunes? So law can work on our side as well. Question I want to ask in response to your kind cue is there any way we can get groups like Hamas to comply with the laws of war? Obviously, their raison d'etre is not to comply. Bin Laden or the Hamas people or ISIS people don't consult law books before they chop off people's heads and commit murder. But the question is there any way we can get them to comply? I don't think so, but I want to examine it. I'll start off by saying, why do states comply with laws of war? And there's a number of answers always given by the textbooks. The first is basic humanitarian principles. A decent person is not going to bayonet a little child or kill an old lady. It's part of basic humanitarian principles. Does this apply to terror groups? It obviously doesn't. They have no compulsion about doing it. So we can strike that off. Second reason states comply is they live with an atmosphere of respect for law. Most states do. Does this apply to terror groups? Clearly not. Another issue off the list. Public opinion. States don't want to have a reputation for being cruel and want to have a reputation for being law-abiding. Does this apply to Hamas or to ISIS? Clearly not. States want their soldiers to have an internal discipline. They don't want their soldiers going around looting and raping. Does this apply to terror groups? No. Reciprocity. Reciprocity is an issue with the states, and this, I think, is perhaps the only issue that we can look at as a way, perhaps, and this is with a great question mark, of inducing terror groups to comply with the laws of war. Reciprocity, by the way, could be, you could refer to the old Latin legal phrase that you all know, he started it. In other words, who started it? That's basically the issue of reciprocity. And it's a basic element of law. We all know this from everyday legal issues. If you buy a house and the person doesn't pay the sum on time, you can delay transferring the house. So this is true of any legal system anywhere. It's also true of international law. A state that doesn't comply with a treaty, the other state can take action on that treaty. It's not bound to fulfill its terms of the treaty if the other side doesn't. A basic principle of law, which is also a basic principle of international law. Trade. If one state imposes sanctions, taxes, or restrictions, the other state can do the same. And those of you who know the World Trade Organization, it has a special dispute settlement board that deals with such issues. The same used to be true of the laws of war. And we have the phrase, a legal phrase known as a belligerent reprisal. And here I'd like to quote the definition, which I take from the American Military Manual. And Colonel kept the same as it's true of the British Manual as well. Acts of retaliation in the form of conduct which would otherwise be unlawful, resorted to by one belligerent against enemy personnel or property for acts of warfare committed by the other belligerent in violation of the laws of war for the purpose of enforcing future compliance with the recognized rules of civilized warfare. In other words, I'm quoting not from some textbook, but from the actual military manual, United States military manual. And it appears, to a certain extent, part of classical international law, when militia, guerrilla groups, under certain circumstances were granted POW, prisoner of war status, by the 1907 Hague Rules and by the 1949 Geneva Conventions. They all specified one of the conditions: they had to carry their arms openly and have a sign that they comply with the laws of war. Tit for tat. In other words, if a guerrilla movement comply with all the terms but don't comply with the laws of war, they're not entitled to POW status. Pure reciprocity. We see this in practical. Poison gas. It was quite clear why the Nazis did not use poison gas during the Second World War. It was because the Allies said, if you use it, we are prepared to use it against you. Neither side used it. Exchange of prisoners of war. Although it's an obligation to exchange prisoners of war at the end of fighting, every state in the world says yes, provided you return our prisoners to you. And in fact, the ICRC, the Red Cross, have acquiesced in this quietly, but they also acknowledge that you can't demand from one state release POWs unless the other state returns your POWs to you. It was used, of course, for the justification for the Allied bombing during the Second World War of German towns, of Dresden. This was act of reciprocity because of the German bombing of Coventry. In other words, it wasn't accepted. However, to a certain extent, the law has changed, and this is what I want to go into it. Gradually, with perhaps under the influence, benign influence of human rights law, certain categories have been removed from the list of permissible objects for reciprocity, for retaliation. Prisoners of war. Even if the other side shoots prisoners of war, you have no right, I don't think anybody would argue with it, to shoot prisoners of war. If they can deliberately kill little babies, it doesn't mean you can deliberately kill babies. If they use, in other words, gradually there's a list of, if they kill injured people, with soldiers, wounded soldiers, it doesn't give you a right to go on in a hospital shooting enemy wounded soldiers. This has been accepted. The one issue which is still slightly open is what about civilians? If the enemy deliberately attacks your civilians, can you attack civilian targets? The rule stands as by the additional protocol that was mentioned as no. However, it's interesting that the United Kingdom made an explicit reservation saying if the other side attacks our civilians, we reserve the right to take action against it. It requires approval at the very highest level of command, but UK, with its traditional, I think, respect for law, but its desire to protect its own civilian population, said, somebody does it to us, we will do it. They haven't done it, in fact, but they made this reservation, and the United States and other European states have made a similar arguments. A strong argument, however, can be made against allowing attacks against civilians in such circumstances. One of them is, basically, you're killing deliberately innocent people. They're not combatants, they haven't done anything to you. Second is, to a certain extent, it's collective punishment. You're punishing these civilians for something the Hamas people did. They didn't do it. An argument can also be made, it's not really effective, because for a group like Hamas, it's an advantage to a certain extent to have their civilians attacked. They can then go to the world and say, look what Israel's done to us. They killed our civilians. They can't, if we just killing combatants, it doesn't make good news, but if you can show a picture of a child being killed. So, whereas in a decent state, killing of civilians would harm them, for a group like Hamas, it doesn't disturb them. And by the way, Israel, therefore, has not adopted this policy of having a right to attack civilians in reprisal. Does this leave us with anything we can do? And here I would like to suggest, talk has been made is, can we change the laws of war? Israel can't change the laws of war. We're a tiny little nation among 200 nations. But in the past, we can raise issues. One of the issues, I think, is, are all government, civilian objects of the enemy immune from attack? And here I would like to raise the possibility, perhaps it shouldn't be so. Normally, you cannot attack government offices unless they're military targets. But one way to deter a group like Hamas is to say, okay, we're not going to attack your civilians, even though you attack our civilians, even though we might be justified under law. That's not Israel's method. However, your government offices, we bloody well will attack. I'm not saying we should attack the Ministry of Welfare, but government offices involved in the administration of Hamas, I think, should become legal targets, even though, again, they're not making bombs. But one way to attack such a group, and we must have some way of deterring them, knowing that there's a price to pay, is we will, and I think legally should have the right to attack government institutions, terrorist organizations, even though they're not directly involved in the military conflict. Again, I'm not talking about hospitals, I'm not talking about welfare, but an organization like Hamas, like ISIS, like Al-Qaeda must know there is a price to pay for attacking civilians. Thank you, Howard.
Thank you. before I turn Professor Korn, I want to ask you a follow-up question. So where would you draw the line between a welfare agency, finance ministry, or a ministry of defense? I mean, where would you draw the line?
Clearly, Ministry of Defense is, everybody agrees, is a target. A welfare organization
even the cleaning person, even the cleaning person of those.
the ministry as such is a target. You're not aiming your rifle at the cleaning, but you're attacking the Ministry of Defense, knowing that the civilian employees there will be hurt. No problem. The Ministry of Welfare is not a legitimate target. Finance is on the gray area. If you hit an organization which is arranging the financing of a terrorist organization, you are gaining an advantage. Are they military targets strictly under the laws of war? Not. But I think in common sense, the financial organization of a terrorist organization should be a legitimate target. Mm-hmm. Thank you.
Okay, so thank you. Professor Korn, I would like to ask you about perhaps alternatives to the principle of proportionality, or maybe you can present your criticism of the principle and perhaps suggest why we should focus on other areas of doctrines which perhaps guide us more efficiently.
Okay. Well, first off, I'd like to share my gratitude for the invitation. I apologize for my voice, but some of you who've heard me speak before may see this as a welcome event, that I may lose my voice in the middle of the presentation. It's a delight to be here with such a renowned group of experts, and I'm very grateful for Shurat HaDin and especially Robert Feldmeyer for all the work he did organizing this. And the discussion so far has basically opened the door to 5 new panels. I mean, we've got the definition of military objective, the conflation of the law of NIAC and IAC, the role of human rights law in influencing the law of armed conflict, the meaning of proportionality or the lack thereof. And I've recently been giving a lot of thought to why proportionality seems to be such a central focal point in the critique of military operations. But I want to start really by going back to the morning and making a couple of points that I think frame my view. First, I think it's a simple reality that legitimate armed forces will continue to confront the dilemma that your former chief of staff identified, the dilemma of asymmetric warfare coupled with what I've called the hypocrisy of double standards. We may be frustrated by it, we may think it's unfair, but for soldiers who are fielded to do the fight for their democratic nations, this is the reality of the operational, strategic, and legal domain that they function in. And I don't think that's going to change, even if we think it's unfair. So the armed forces do have an obligation to conduct their operations within this double standard framework. And we have to get used to that, because it's not going to change. I personally don't think that that's all that new. I think this has been an element of warfare forever. You can find examples in history of professional armed forces fighting unprofessional asymmetric enemies that didn't follow the law, and much of the law of war that evolved with an expectation of unilateral compliance even when you face that enemy. And I'll come back to that at the end, because I actually think that the IDF is an icon for this principle, that we should be proud of the fact that the Israeli Defense Forces hold themselves to a remarkably high standard of conduct, knowing that the domain that they are going to function in is a domain of hypocritical double standards. And they do it not because it's only an international expectation. I am convinced they do it because their commanders understand that it's essential to preserve the moral integrity of the young men and women that they're sending into combat. So I personally think that it's not realistic to demand that the law be modified or changed in a way that's going to allow more permissive use of force at the expense of civilian populations. Having said that, I also believe that it's devastating to allow the law to continue to be distorted in a way that functionally neuters decisive military action in war. I think the law is flexible enough to respond to the range of threats that armed forces face today, so long as it's properly understood and properly explained. So the flexibility is there. The problem is the distortion of the law. And I believe that the proportionality rule is a key cause in this distortion for a number of reasons. So my ultimate thesis or focus of my presentation is I actually think the proportionality rule is of very limited operational and tactical utility because of the amorphousness of the rule, because of the inherent subjectiveness of the rule. And yet it has become the focal point of critique for military operations, and that's created a distortion in the relationship of the rule for the commanders, like Colonel Kemp, who's trying to decide whether to conduct an operation, versus the relationship for the external community that is interested in critiquing the conduct of those operations once they're done. So it is, in the view of many, the focal point for the dilemma that the Chief of Staff identified. The LOAC rules, and I call it the law of armed conflicts. I tend to avoid the term international humanitarian law for a simple reason. I don't think there is anything humanitarian about war. War involves closing with and destroying your enemy, imposing your will on an enemy through the application of lethal combat power. I certainly recognize there's an important humanitarian component, but it's not humanitarian law. It's the law that regulates armed conflict, the contemporary evolution of the laws and customs of war. Now that law, as Colonel Jackson noted, is built on a central balance between military necessity and humanitarian constraint. And proportionality is an obvious substantive legal rule that reflects that balance. But the locus of the proportionality rule in the broader rule that prohibits indiscriminate attack, I think, is important because it goes to the point that my friend and colleague Professor Jenks raised. Proportionality in the law of armed conflict context is not, I don't think it was ever intended to be a close balance. The decisive word, the fulcrum word, is the word excessive, not disproportionate. Disproportionate, I believe, means something different than excessive. Excessive means a significant imbalance, so significant that it would be apparent to any moral warfighter that the justification for inflicting that civilian risk cannot pay its way when you consider what you're going to get out of that risk. That's what the law was intended to provide. However, I think lawyers have in large measure hijacked the meaning of this word because lawyers love balancing tests. They love tests that enable us to look at different sides of the equation. And also, if you think about it, proportionality is a logical kind of gravitational focal point for individuals who want to critique and assess military operations because it's the ultimate manifestation of this balance between military necessity, the interests of military objective, and humanitarian interests, the protection of innocent civilians, because as Chris identifies, the hard reality of the rule is it's a rule that acknowledges that in war, commanders make calculated decisions to kill innocent people, not deliberately. When I hear on the news people talk about collateral damage as being accidental, I get very frustrated. Because if it's really accidental, it suggests to me that the commander didn't fully accomplish his mission. Because the commander has to know the risk of the attack, anticipate the risk of civilian harm, and then make a calculated decision about whether that risk is worth the benefit that he expects to get out of the attack. That is a hard reality of war. So it's logical that this rule would become the focal point for critiquing the collateral damage and incidental injury that is inherent in warfare. Having said that, I also think that at the tactical and operational level, the rule has very limited utility. Because when a commander is making this decision, even if a legal advisor is involved in this decision-making process, the commander will look at the legal advisor and say, what am I allowed to do? The legal advisor will say, you're allowed to launch the attack so long as the civilian risk is not excessive. Now put yourself in the position of the commander. What's the follow-on question? Well, what is excessive? And the lawyer is going to look back and say, I don't know. It's up to you, sir. You're the commander. You have to make the judgment. it is so highly subjective that I believe outside of the extremes, it provides very little utility for the commander. Now, at the extreme levels, it should matter, and I believe that's why it was included in Additional Protocol 1 as a reminder that there is a limit to the point at which attacking a lawful target is permissible or impermissible. But it has to be something that seems fairly clear. And that goes back to the point that Colonel Kemp made this morning. Even in the ICC statute, the criminal violation of the rule is not that the attack created excessive civilian risk, but clearly excessive civilian risk. So there's even a higher standard to establish criminal responsibility. On the other hand, the fact that it is so complicated, the fact that there are so many variables that go into the equation of what is or is not a violation of the rule, because as my colleague Eugene said, it's not a retrospective assessment, it's a prospective assessment. We are judging the commander based on the decision he made at the time to launch the attack, not on the effects. That is very difficult to recreate. I may be the only panelist up here who spent 4 days being cross-examined by a prosecutor at the ICTY when I was called as an expert witness for a commanding general who launched an attack and was accused of launching an indiscriminate attack because it was disproportionate. What was so complicated about that was you had to go back and consider every factor of the operational and tactical equation that went into that decision-making process. That's really hard to do. Oftentimes, it's impossible to do because of secrecy, because of lack of information. So what I think it's contributed to or led to is the easier solution of effects-based condemnations. So instead of looking at the military situation, recreating the commander's dilemma, deciding whether the judgment was reasonable, not necessarily the best choice, but within a range of reasonable decision-making, which is what the law demands, it's much easier to just focus on the emotive images of civilian casualties and say that had to have been a violation. Look at all the civilian deaths. That had to have been wrong. But that produces a complete distortion of the law, and it subjects commanders to a strict liability standard where their judgments have to be right all the time. And here's another difficult reality. No commander, no matter how cautious, no matter how moral, can ensure that every attack decision is right. What we demand of commanders is that they are cautious, that they're reasonable, and that they are moral. And the rule is designed to do that. But when we substitute effects-based analysis for the actual difficult task of recreating the situation, we are distorting the meaning of the rule. And that distortion, I think, is imbalancing, leading to an imbalance of the entire equation of the law of war writ large. What I think is most troubling about this is in many ways, I think it's distracted our focus from a much more important rule to limit and mitigate civilian risk, and that is the rule of precautionary obligations. Precautionary obligations are much more objective. The commander can say, I want to attack this building, and as a legal advisor or a fire support coordinator, I can say, have we considered changing the time of the attack? Have we considered changing the weapon of the attack? Have we considered whether or not a different objective might produce the same outcome? These are objective measures that the commander can say, I can go down a checklist, and I can say, we considered warnings. We considered a different weapon. We considered different timing. They're not purely subjective. Now, I recognize there's an element of subjectiveness in there. So, for example, the warnings requirement. You have to give a warning unless doing so wouldn't be feasible. So there's an element of judgment there, but it's much more objective than this proportionality rule. And if we expand the meaning of precautions, it holds much greater benefit. for mitigating civilian risk, the precautions of effective training, the precautions of integrating military lawyers into the target decision-making process, the precaution of accountability mechanisms. All of this together, this package of efforts to mitigate risk through objective, feasible, and verifiable techniques is a much better indicator of legitimacy than this myopic focus on proportionality. And ironically, if we look at that, it also produces another outcome. It provides circumstantial evidence of good faith efforts to comply with the obligations of the law, to mitigate the risk to civilian populations. And it's also a reflection of the moral foundation of the military that's conducting the operations. And this is what I find most frustrating about the contemporary discourse of military operations from Israel, from the United States, from the United Kingdom. When I look at the efforts that these military commanders at the highest levels, working down through the chain of command, go through to implement meaningful precautionary measures, I think it's completely naive to suggest that they are not committed to achieving the balance of the law. It doesn't mean they always get it right, but it's a powerful indication that they're trying to get it right. And that's what we should reward. We should not condemn it, and we should not dismiss it. So my ultimate suggestion is this: let's keep proportionality where it belongs, as a limit on excesses that simply cannot be justified even when we recreate the tactical or operational situation. And let's start focusing our efforts on implementing precautionary measures that mitigate the risk to the civilian population, while at the same time enabling military commanders to use the lethal force that their nations have entrusted to them to bring about the submission of their enemies in an efficient and effective manner that limits the risk as much as feasible under the circumstances.
Thank you very much, Professor Korn. I want to apologize on behalf of Professor Sable, who may need to leave us abruptly. Thank you very much, Professor Sable. I would like to open up, before we open for Q&A, to raise a question of the second order. Question that basically touches on the issue of justifying laws of war in general and the proportionality doctrine in particular. And that is as follows. It seems to me that, as I said initially, it's very hard to understand why would an individual or a collective or a nation would restrain themselves, sometimes on the expense of their own lives, in order to abide by some legal doctrine. I mean, if you believe you're acting, you're fighting for a moral cause, it would seem to me any means necessary to attain that moral victory are morally desired. So therefore, the introduction of legal restraint needs this justification. And I think that there are two sets of justifying arguments may be made. One is a utilitarian-based, meaning, well, when we abide by legal doctrine, we gain other advantages. But that, I think, only carries us to some extent, because at the end of the day, when the utility doesn't pay off, then you cross that line. The other sets of justifications is usually, I'd say, Kantian or more even religious justification, that if you believe in an absolute value, meaning, yes, sometimes you're willing to pay a price, even if it is with your own life or your people's lives, because you want to abide by some absolute value or principle. Now, the irony is, I think, that we live in an era of postmodernism, of the decline of absolute values in society, on the one hand. Therefore, it seems to me that justifications for laws of war should be less forceful. But on the other hand, we see an influx, or I would say overly an obsession with the laws of war and principles of proportionality, etc. So this is an interesting paradox, which I would like to hear your take on it. First of all, how do you, what would be your favorite justification for such doctrine, and how would you bridge that paradox that please?
Well, I would start by suggesting that you're missing what I think is the most overlooked and vital purpose for the law. The law preserves the morality of the individuals who we require to take life on demand. Now, maybe in Israel that's not a concept that's alien, but in most Western democracies today, the idea that somebody could point to another human being who's not at that moment threatening you and say, kill him, and it's not your right to do it, it's your duty. That is a profound departure from the normal relationship of human beings. And I think the law didn't come from lawyers. The law came from military commanders. That's its origin. And I think military commanders have understood forever that if you want a disciplined moral force, you have to preserve a line between right and wrong, even in the most chaotic situation, right? I want to just read something. This is, I think, pretty interesting. This is the approval of the conviction by court-martial of an American brigadier general by Theodore Roosevelt, who was convicted of authorizing the abuse of detainees in the Philippine insurrection in 1902. This is what President Roosevelt, who was no alien to war, he understood war, this is what he wrote. The findings in the sentence of the court are approved. I am well aware of the danger and great difficulty of the task our Army has had in the Philippine Islands and of the well-nigh intolerable provocations it has received from the cruelty, treachery, and total disregard of the rules and customs of civilized warfare on the part of its foes. I also heartily approve the employment of the sternest measures necessary to put a stop to such atrocities and to bring the war to a close. But the very fact that warfare is of such a character as to afford infinite provocation for the commission of acts of cruelty by junior officers and the enlisted men must make the officers in high and responsible position peculiarly careful in their bearing and conduct as to keep a moral check over any of conduct of an improper character by subordinates. And one of the best examples of this is from a book that was written by an American platoon leader in Vietnam, James McDonough, not a lawyer, an infantry platoon leader. And he said, my job as a leader was to help these soldiers navigate the moral abyss of mortal combat. I was making them kill. I was making them do the most inhumane acts, but I had a duty to make sure that when they came out at the other end, they preserved a sense of humanity and morality. So I don't think it's just utilitarian. I don't think it's just reciprocity. I think it's an obligation of responsible leadership that when you fight the most illegal, inhumane enemy, you actually ramp up your commitment to respect for humanity, or else you lose all semblance of it.
Any more marks? Any more marks? So I'd like to open it for a Q&A.
Our friend Colonel Kemp made the distinction between coerced civilians and voluntary civilians. When Sparta fought Athens, the civilian population completely supported those wars. For 100 years in Greece, when the city-states were fighting, the same was true. In the American Civil War, the South, the civilians of the South supported, financed, and did everything they could to support their soldiers. They were active in the war against the North until General Sherman brought the battle to the civilians. And it seems to me, except for Colonel Kemp, most of our speakers are ignoring the culpability of the civilian population and not addressing it with this legal framework. So where the civilians are support and also handcuffing completely military action, because if you can't take the battle to the civilians, then the war is endless. It's endless. There is no possibility of surrender, as happened in World War II, certainly the German population completely supported the Nazis. And now what you're asking is, especially in the case of Israel, that we should be handcuffed. when we know the civilian population is in most cases completely supporting the attacks, the missiles that are flying over our heads and over our children's heads.
Thank you. Everybody.
Thank you. Let me take this. Is this on? The civilian population of an entity like Gaza is not immune in the sense that Israel can bring to bear a variety of sanctions upon Gaza. And this is what countries can do and often do in terms of conflict vis-a-vis enemy populations. The laws of war, call them LOAC or IHL, take the basic ideological point of view that you do not target civilians. You do not want to go back to the total war era. This is really the dividing line. Thank you, it's okay. But this is really the dividing line between the pre-1945 rules of war that allowed essentially total warfare and the post-45 laws that did draw this distinction. Mind you, this game has two participants. The Israeli public also supports the IDF. Would we accept a legal rule that allows as a result Israel's enemy to target deliberately civilians? We don't, and we shouldn't. Of course, they do, and that's why it's a war crime, and they should be prosecuted for committing these war crimes. That's a problem. But in terms of identifying what the law is, what the right thing to do is, if we are ready to take the position that the right thing to do for Israel is to target Gaza civilians, then by necessary correlation, it is the right thing for Hamas to target Israeli civilians. This is not a world in which we want to live. We've been in this world and we've seen the consequences, and they were horrible.
Let me speak also briefly to this point. I would dispute the factual premise. I would dispute the factual premise and actually say it's unknowable. The premise here is that the people support Hamas. First of all, what the people anywhere think is very hard to determine, but certainly in an unfree society. In an unfree society, to say what the people do or do not support is almost unintelligible, right? You may elect Hamas once, but once they're running the show and you're not free to engage in normal forms of politics and dissent, what the people think is a complicated feedback between what they actually think, what they're told to think, what they're afraid to think, what they think they need to think, and what anyone actually supports and doesn't support in a totalitarian society, which I think Gaza is close to, or at least an authoritarian and restrictive society, it's impossible to say. And so to do something as heavy as ascribing, to take action against the people because of their perceived thoughts, when those thoughts are unknowable, I think is a very hard thing to do.
Thank you. Next.
We only have time for a couple of more questions, and I really must insist that a question is asked.
I have to question why my name is Barry Weiss, why you are looking at the micro and talking about so many deaths and winning a battle or a confrontation, where Hamas has said clearly they want to eradicate the Israeli state, and they're against all Western values. So you can't say, let's look at their culture and give them a pass. And I contest what you just said about the fact that you can't say that all the civilians should be given a pass. All the polls indicate that not only did they elect Hamas, but they are indoctrinated in this idea of hatred of Judaism and Western life and the Israeli state. And so we need to be proportional in saying we must eradicate Hamas. You can't reform them or take them down and think that you'll gain anything. They must be eradicated, and that's the proportionality. And I want to know why you can't focus on that.
Well, let me try that, because we were asked to comment on the use in bello principle of proportionality. The state defines the military strategic objective. The soldiers do not. The commanders that go to the field to conduct the operation are given a mission. If the mission is neutralize the rocket threat against Israel. Then the commander figures out what the center of gravity is. He does his assessment. He figures out how to most efficiently achieve that. And there's a lot of confusion on proportionality in that context. But you're talking about a completely different theory of proportionality that none of us were asked to address. And candidly, as a law of armed conflict expert, I don't feel competent to address.
You're quite, yeah. Okay, what's the next more questions?
Okay, I'm actually going to give the microphone to a member of the press from the Jerusalem Post.
Hi. Yonah Bob from the Jerusalem Post. Professor Sable just went on record with qualifications, willingness to strike a finance ministry in the context of war. Professor Michael Schmidt, one of the top experts in the United States, in a recent article articulated a similar position with some qualifications. I'd like, as short as possible, each of the panelists to give what their position on this, because it's a cutting-edge issue.
Well, I don't think, candidly, if I were a legal advisor in a command and you asked that question, I'd say, I don't know how to answer it yet, because I don't have enough information. I need to know everything. I need to know where they're getting the money, where the money is going to, how the money is being used, what is the relationship between the belligerent command forces and the financiers. I think in some circumstances, you could build a strong enough case where the finance capability is a lawful military objective. In other circumstances, you couldn't. It's context dependent.
And I would say the same thing, and you've seen this play out in Afghanistan with the narco trafficking, where there's been times where the U.S. has contended that is direct participation in hostilities where the linkage is strong enough, and that's a position that I know most of our NATO allies disagree with.
So Professor Sable, as far as I understood him, was arguing for expansion, progressive development of the law to allow targeting some things that are not direct participants, but would not overly hurt humanitarian interests, but would still affect the calculus of a non-state actor otherwise dedicated to the commission of war crimes. And he admitted there's not much one could do, and he suggested this as an example. Again, I don't see if Hamas were to lose like the headquarters of their Department of Motor Vehicles or something, or their finance ministry would have to, build a new building. I can't see that as affecting the decision making too much.
We're going to take two very quick questions. Very quick.
So, Professor Korn, in terms of this military literacy that you mapped out very well, and this paradox you said of, on the one hand, there's this gap of values, on the other hand, there's this cry out for greater values. I'm summarizing very quickly. How do you suggest we bridge the fact that at one level it seems like this kind of military institution of values is becoming more important, and yet we have in our history that when values are, if you will, instituted militarily, it's generally associated with dictatorships and things of this nature. I'm really quickly trying, can you speak to that gap?
I think that one of the most significant challenges in articulating the credibility and morality of Western military operations, and I think most notably IDF operations, is humanizing the warrior, right? When we have the warrior, right, we forget, and I don't understand why we forget. Maybe you don't forget in Israel, but I think it's forgotten largely outside of Israel, that the people making these decisions are moral people. They come from among us, right? Why would anybody think that a military commander would have an interest in inflicting excessive or unnecessary civilian casualties? To me, it's perplexing. As a matter of fact, I think it's the military commander who has one of the strongest interests in mitigating the risk of innocent casualties, because that's the person who has to make the decision to do it. I worry about this lack of understanding. Externally, people see the military as like a machine. My son is about to become a drone pilot in the U.S. Air Force, and I look at the press in the United States whenever a mistake is made, and the automatic ipso facto conclusion that there must be an illegitimate, illegal, immoral decision-making process, and it infuriates me because I expect the people in charge of him to have a strong sense of morality, and I think that's what the law has been built on forever. So part of this, I think, is to do a better job of reminding the international community and the comments about the international press. During Protective Edge, I did a lot of media in the U.S., on CNN, on PBS, and this was a point I made consistently. They were shocked. I said in the discussions prior to the interview, I've studied with IDF lawyers. I've worked with IDF lawyers. I know the type of people they are. Trust me, they are trying as best they can to minimize risk. Really? You know them? You think that's how they think? And I was stunned. So I think it's incumbent really on the IDF. I think at times it did. I think that, and what's the alternative? To just kind of capitulate? You have to keep making the point that there's but that's why that precautionary process is so valuable, because that's objective. Then I could say, look at all the things they do to minimize risk, and you gain a sense of credibility from that. We need to focus more on that and less on this kind of macro, how many were killed, how many needed to be killed debate.
Okay, last question from a law student here in Israel.
Thank you. My name is Ran. I'm a law student at the IDC. I'm actually a former lieutenant in the Paratroopers Brigade. And first, I must say something as a soldier. Despite the question that was asked, the Army is obligated to protection of lives of innocent people in the battlefield. And I served in the last operation in my reserve service in Gaza, and that's something that you are being educated from your first day in the IDF. So that's the first thing. What I want to say as a civilian, an Israeli citizen, and I have this very distinguished panel here of law experts, and as an Israeli citizen, I want to defer the Israeli battlefield in Gaza or in southern Lebanon than the challenges of the US and the UK in Iraq and Afghanistan, because here the Israeli civilians are also affected from the war. And as an Israeli citizen, it's not of a question, it's more of a statement. I feel that the international law does not protect me. I have no international law medicines to get from courts or from anyone because Hamas is not obligated to international law. So what happens is that international law protects the peoples of Gaza, but it doesn't protect me. So that's what I want you to address. Thank you very much.
Okay, everyone. First of all, thank you to our panelists and to Dr. Arnon, our moderator. We're going to take about a 10-minute break. We ask everybody please to be back in their seats at 3:40.